So the Court of Appeal hearing to decide if there should be a retrial in the murder case of Vybz Kartel is now over. Here are 5 things you need to know about the final day of the hearing. Stay tuned. Number 1, the prosecution says it's in the interest of justice for there to be a retrial. According to acting DPP Claudette Thompson, she said the court shouldn't dismiss a matter like this because of a technical blunder, because it's in the public interest that people who have been accused of crimes should be tried and, if convicted, should be brought to justice. She named the factors she said are in favor of a retrial: the seriousness of the offense, that is murder, the prevalence of the offense in Jamaican society, also availability of witnesses. On a previous hearing date, questions had been asked about that. Well, she said witnesses are available, and she also spoke about the strength of the prosecution's evidence. 2, in responding to the comment, the submission about the strength of the prosecution evidence, Attorney at Law John Clark, who is representing the accused men, who is speaking on behalf of the accused men, raised questions about some of the exhibits. He said there were 25 exhibits in the first trial. Now, during this hearing, the prosecution presented a list of exhibits that they said had been verified as being available in the event of a retrial. But Mr. Clark said, hold on, 25 exhibits in the first trial, but there are only 16 listed here as being verified. He said 2 of the most important exhibits were not listed. 1, the DVD containing the video of the murder. 2, the DVD containing the voice note supposedly sent by Kartel. He also said that some of the exhibits relied on by the defense were not listed as verified either, such as the signature of the sole eyewitness Lamar Chow, also a letter to the public defender. According to Mr. Clark, the court now has to take into account the fact that these vital exhibits have not been listed as verified when they're going to be assessing the strength of the prosecution's case. 3, the court looked at the sentences that the men had received during the first trial, at the end of the first trial, and looked to see whether or not they would be prejudiced this time around by the length of time they've spent in custody. Now, under the Offenses Against the Person Act, a person convicted of murder in this type of circumstance can be sentenced to life imprisonment. And in that case, the court has to set a 15-year minimum before they can be eligible for parole. Now, both Kahira Jones and Sean Campbell, all the 4 men, I should say, had been sentenced to life imprisonment, but different time periods in terms of eligibility for parole. So Kahira Jones and Sean Campbell had been sentenced to life, and they could only be eligible for parole after 25 years. In the case of Andre St. John, it was 30 years. In the case of Adidja Palmer, it was 35 years without being eligible for parole. What the court looked at is the length of time the men have already been in custody. That is nearly 13 years. If a retrial is ordered, they could be in custody another year, perhaps another 2 years. Say they're in custody for 15 years, it would mean that they would then have served at least the minimum time that the court would have ordered in a sentence before they could be eligible for parole. The response of the acting DPP to this was that, well, given the circumstances of the case, she wouldn't envisage that eligibility for parole would be set as low as 15 years. Therefore, she doesn't think they would be prejudiced. 4, the judge asked, why is this case different? What makes this case special? And she was asking in the context of the fact that we've heard recommendations and talk about the possibility of this case being set as a priority case to ensure that the men who have already spent all this time in custody wouldn't then be spending another long period in custody if it is that they're not granted bail if a retrial is ordered. Now, the comparison the judge made was that of the case of Trevor Taff. Now, Trevor Taff was convicted in 2016 for the 2012 murder of the mother of his child. Her body was found on his property in a septic tank. And obviously she had been killed in a pretty terrible way. The body showed stab wounds. She had been decapitated. And what the court said, what the judge asked is, hold on, here is a case involving distressing circumstances, a young woman, a mother of a child, and she was killed in pretty terrible circumstances. So what makes this cartel case so different and so special that it should leapfrog cases like Trevor Taft that are waiting for retrial? What the prosecutor said in response was that, well, they're not trying to compare victims of the case. What they are saying is that in this case, a cartel case, they're ready for retrial. They'll be ready as early as the next court term, which begins in September after the summer break. And 5, looks like we're going to have a speedy judgment here. The presiding judge, Marva McDonald Bishop, said the court is going to be working assiduously to deliver a timely judgment. They're aiming for a judgment by the end of this current court term, which ends at the end of July. So, of course, we'll be watching out for that. I'll be keeping you updated on everything. Make sure you check back here. And until next time, thank you for joining me courtside.